Generally, amending or modifying zoning ordinances or regulations is considered a legislative act. But what about small-scale zoning changes that only affect a small number of people? Are these types of decisions considered quasi-judicial rather than legislative, requiring the determination to be supported by competent substantial evidence? The Florida Supreme Court considered this question in Board of County Commissioners of Brevard County versus Snyder. Jack and Gail Snyder owned a half-acre of land on Merritt Island in Brevard County, Florida, that was zoned for single-family homes. However, the Snyders wanted to build a multifamily home on the land and applied for rezoning with the Brevard County Planning and Zoning Office. The Planning and Zoning Office's staff reviewed the Snyders' application and recommended that it be denied because the land was in a restrictive floodplain. However, at the next board meeting, the office's director determined that the restriction wouldn't apply if the property was developed because it would be raised. The board then voted to recommend approving the Snyders' application. Afterward, the board sent its recommendation to the Board of County Commissioners of Brevard County. At a public hearing, many citizens spoke in opposition to the zoning application, and the commissioners denied the Snyders' application without stating any reasons. Subsequently, the Snyders filed a petition for a writ of cert in State Circuit Court, which the court denied. The Snyders then filed a petition for review with the 5th District Court of Appeal. In granting the petition, the Court of Appeal explained that a rezoning decision that applies only to a small number of people is quasi-judicial in nature. Further, it stated that in reviewing quasi-judicial actions, a court applies a strict scrutiny standard, under which a governing body must provide reasons for its denial. With this standard in mind, the Court of Appeal found that the Commissioner's denial of the Snyders' application was, as a matter of law, arbitrary and unreasonable. The Commissioners appealed the decision to the Florida Supreme Court.